Hi everyone, I'd like to welcome you to the Ethical and Legal Consideration in General Practice webinar. So this is a part 2 series and we'll be presenting part 1. So today's session is funded by Partnered Health Medical Centres. And before we begin, I'd like to do an acknowledgement to country. So we would like to acknowledge the Aboriginal and Torres Strait Islanders people as the traditional owners of this country. We pay tribute to their physical and spiritual connection to land, waters, community, enduring now as it has been throughout time. We pay respects to them, their culture, to elders past, present, and emerging. Just a few housekeeping rules before we start. So microphones are on mute, please, during the session. You're able to submit Q&As through our question box feature through Zoom. So any questions, I'll be moderating that. Any questions, I'll pass on to Paul. Please let me know if there is any technical issues using the chat feature. There is an evaluation at the end of the session. Please complete that. And a statement of attendance will be sent out after this education session. I'd like to formally introduce Paul. Paul, thank you for being here tonight.
My pleasure.
So Paul has an extensive experience in health law. Since 1991, he has advised and represented doctors in many matters, including medical negligence claims, inquest hearings, professional conduct, disciplinary proceedings, and Paul understands the stresses or strains Avant members face in the daily practice of their professions and their needs for medico-legal support to help them do what they do best. And I'll hand this over to you, Paul. Thank you.
Thank you, Visala. Just let's just make getting the presentation up.
Great.
Yeah. Thank you, everybody, for joining in for this presentation. I hope you find it very interesting. It's an area of medical practice everybody should get a handle over because complaints are going to be made, and it doesn't mean if you get a complaint that there's anything wrong with the way you practice. It's just that it can happen. So let's kick off. So just the first slide here, we're just covering, what the agenda is for this evening, at least for the first part about complaints and how to manage those. Okay. Now, complaints and, where, how do they emerge and where do they go? Now, the emerging situation, that would obviously be a patient who's making a complaint. Often that can be, small complaints, trivial, what you might be considered trivial complaints. Sometimes they can be very, very serious and something may have gone wrong because we're all human beings. We have their systems, could be systems issues, could be an interpersonal issue, could be just some inadvertent act or omission, and there could be nothing to the complaint. But there will be a complaint of some sort. Now, they could be, I'll get into the levels and stuff like that, but they could lead to a direct complaint from the patient to the doctor or the practice. They could be a direct complaint to APRA or the regulator, or you could have civil litigation. Now, how it can come with you is very, very, you can't put a rhyme to it. You could have a patient just making a complaint and nothing more, but you could have a patient making a complaint, not being satisfied, and then going to APRA and complaining to them. Then they could also commence civil claim against you. Alternatively, they can go straight to APRA. I have also seen that's less common, but it does really happen. The patient will sue the doctor or the practice or doctors, hospitals, and then after the matter settles and is finalised, they'll complain against the doctor to the regulator. So it can come at you in a number of ways, but ultimately there's often a complaint that sometimes you have to deal with. And just this slide here shows us, from advanced numbers, the complaints, disciplinary complaints, as opposed to other types of legal proceedings, common legal types of matters that we have. And you can see the blue line there, that's going up far, far greater than civil matters and other types of matters. They're mainly employment privacy disputes and stuff like that. So privacy breach matters, anti-discrimination matters, the Green Line and employment matters, and training disputes, and a whole bunch of other things, Medicare matters. But you can see the biggest line and probably the biggest volume of matters in terms of numbers is the complaints. So they are by far the largest component of what we do in what my team does, and I expect what we do nationally. So this slide's about encouraging patients to complain. And I know it might sound counterintuitive that, you know, you'd invite people to complain, but you're better off having a complaint come to you rather than go to a regulator. I'm not saying the regulator do anything wrong, but if you can resolve it yourself, you should resolve it yourself. Yeah, so patients do make complaints. They like to be heard. They like to make their point, take their complaints seriously, train staff how to respond to complaints. Ideally, have a policy or procedure in place has to manage a complaint, and take the complaint as an opportunity to improve, have a self-improvement process. Now, going back to having a policy, the worst thing is if a complaint comes in and nobody knows what to do with it. There should be somebody who can, you know, log the complaint, escalate it up, assess it. You know, how serious is it? Is it a small complaint? Is it something that can just be dealt with a conversation? And important too is to have some record and how it's been finalised and what's been done to close it off. Just before I go on, this is not on a slide, but it's actually also an ethical requirement. The Medical Board of Australia has a document called the Code of Conduct for Doctors in Australia. And at 4.12, it actually says that good medical practice involves acknowledging the patient's right to complain, providing information about the complaint system, working with the patient to resolve the issue locally where possible. So again, that encourages, they're saying, try to work it out at your level. Don't have it go up to them. The last thing they want is everything going to them. Providing a prompt, open and constructive response, including explanation and, if appropriate, an apology. Ensuring the complaint does not adversely affect the patient's care. In some cases, it may be advisable to refer the patients to another doctor. Complying with the relevant complaints, law, policies and procedures, reflecting on the complaint and learning from it. So that's in the Code of Conduct, which is the doctors or the medical board's guidelines, ethical guidelines for doctors in Australia. So it's an ethical issue also for medical practitioners.
Sorry, Paul, just
Yes.
quickly.
Yes.
I'll just get you to hover to the full screen mode, and
Yep.
so everybody can just see it more clearer, I think.
Yes.
Yes, thank you.
So we're right to go next slide.
Yeah, just hover to the full screen mode at the presentation part.
So can you see this now? Is it all okay?
Yeah, we can. It's just just hover your mouse down to the full screen mode.
Okay.
Yes.
Down here?
Yes, down here, and there should be like a little whiteboard with 2 sticks at the bottom. Do you see that? A small little logo? Yeah, and just move across next to the
here.
yeah, and then move across to the next one, to the other small little logos.
I'm sorry, I'm not getting it.
Yeah, no, that's okay. We'll just do you see the minus and plus button for the screen for the PowerPoint?
Yes.
Yes. So right next to it there is a little logo that one. Yep, slideshow.
Okay.
Great. Thank you so much.
Okay, that's okay. Sorry about that. And I'm not very techie, so sorry.
That's okay.
So complaints, your risks. So obviously there's professional reputational issues. It's not going to happen from a one-off, but these days it may with social media, commercial impacts and stress, which is probably the worst thing for healthcare professionals. Now, this slide is a
Sorry, Paul.
yep.
Sorry. Again, just hover to the got it button on the orange, just on the side. There's a little, an orange square. Just press got it.
Okay. Is that okay?
Yeah, that is
Perfect.
okay.
Yeah.
Yep, and yeah, that's
Okay. Sorry for all these technical issues. Okay. Next, patients wanted to be heard and understood. This is what patients want: an explanation, an apology, and something to change. Now, with this slide, it's a combination of a number of studies that we've come up with this slide, but there's more to it. Sometimes they want accountability, they want prevention, immediate or additional treatment, an admission of error, punishment. And so these are all drivers why people make complaints. One thing I would say in my professional experience, even the complaints you think are really unreasonable, they're often not driven by maliciousness. They'll be driven by a misunderstanding of the patient. People very much believe in their complaint. They may have it wrong in making the complaint, but it's often borne out by a misunderstanding, not being knowledgeable, and they will make a complaint, but that doesn't mean they don't believe in it. Oh, sorry. So I just want to go back up. So prevention. Importantly, managing patient expectations is a key element. And hopefully when you're having a chat to patient, a discussion with them in a consultation, you will get a feeling that they're understanding what you're talking about, the treatment you're proposing. And I expect most times it'll be like that. But, if you have to ask something because it's appropriate, like, what are you hoping I can, or, I can do for you, or what the outcome of this treatment is going to be. Sometimes it's appropriate to ask just to make sure the patient understands and to manage their expectations. If they have expectations which you clearly can't meet, then obviously that may mean you should not continue on with that particular patient. Follow-up is also, so I'll go through consent first. Consent aligns with what I've been talking about, the consent process, and making sure that they have an understanding of what's being proposed and why it's being proposed, that you discuss risks relating to that particular procedure. Goes hand in hand with good communication, follow-up, and sometimes when something might go wrong, if there's an adverse event, it's important to follow up with the patient. One thing that patients don't like is inadequate follow-up. If they think that if you say you're going to be there at a particular time or do rounds and nobody comes around, it doesn't help. Clinical competence is another issue. Stay within the limits of your skill set, and that goes hand in hand with knowing your limits. Actually, we tend to find no criticism. I'm not sure the background of a lot of the practitioners here, that I think younger practitioners starting out might have an issue with the limits of their involvement in the patient's care in terms of their professional training and experience. But all these factors go together to hopefully preventing, if you're good at managing expectations, good at the consent process, good communicator, that's a two-way street. Good at following up, and clinical competence and knowing your limits align. Hopefully all that will limit. Can't guarantee that it's going to stop complaints. That's never going to happen, but hopefully it'll limit complaints to very few, and if they do happen, they'll be minor complaints. Now, the complaint management process. A complaint will usually be by a patient, but not always. It could be by a parent. It could be by a child, like an adult child in relation to their elderly parents. It could be by anybody related to the patient, a carer who's not necessarily a blood relative. So, patient or anybody who's closely related and knows what's been happening to the patient can complain. Now, the complaint can be to the practice or to the doctor, and we call those informal complaints. They can also be formal complaints, and that's up here. That's a complaint to an agency like the Medical Board of Australia / APRA. And with those, I would advise people to contact, if you're an Avant member, contact Avant or contact your MDO. I wouldn't be advocating for people to respond to their own to a complaint to a regulator. A lot of times it'll be fine, but I know I've seen too many times when people respond to a regulator on their own and it doesn't stop. The matter goes on, when often a better phrased response may have averted that. All we do as I'm a solicitor, and an MDO, we optimize the response. We've never changed anybody's, we never put words in people's mouth, but we help people optimize their response to a complaint. That's it, be able to reflect what happened better and respond better to the medico-legal issues in play. So if you get a complaint from a regulator, I strongly recommend that you go to your MDO. And I actually have even heard complaints bodies, like in New South Wales where I am, at talks, when they give talks, saying, we encourage doctors to go to the MDO, and when they get a complaint, they'll tell doctor, take it to your MDO, because they like to deal with people's MDOs. Only because they know the doctor will get advice, and they'll be able to put their best foot forward. Now, sometimes, ask the patient to clarify the complaint. It's a good idea. You'll know when it's really, you can handle it in a discussion. If it's long, there's many facets to the complaint and it's very serious, ask them to put it in writing. It's the best way. And why would you do that? It crystallizes everything. It actually also creates an agenda that you can respond to, either in writing, if you're going to have a face-to-face conversation and go through a discussion with the patient, go through with them. It gives you something you can respond to. And then you can also follow up with a written response about how you've closed out the matter, what was discussed and how the matter was closed out. And I would say that when you receive a complaint at this juncture, I would endeavour to get back to a patient within 24 hours. I wouldn't leave it more than about 48 hours to get back to the patient. The longer it takes to get back to the patient, the more likely they're going to feel like there's nobody's listening, and their anger is going to grow. So I would get back to a patient within 24 hours to 48 hours. And again, if you have a policy where patients can express concerns, and I wouldn't express it in making complaints, that policy and that procedure may actually allow the patient, feed back to the patient about when they can expect a response from you. So this is just continuing the same theme, informal resolution. So these are, again, complaints which aren't made to a regulator. So if it's not made to you directly, like when you're in a consultation, give the patient a call. If it's an email, then email them saying you'll get back to them. Again, in the same vein I've just been talking about, clarify concerns. It's okay to empathise with the patient and apologise if necessary. You don't have to, admit fault. You don't have to talk in terms of fault, but to say, look, I'm sorry you feel this way. I apologise that you have to go through this. That's not admitting fault. That's just, acknowledging their feelings and saying sorry that this has happened to them and they've had this anxiety or this upset. And have a low threshold for formalising the process and asking to put it in writing, because I think once you put it in writing, you can take your time and consider it. You might get flustered in a discussion, especially if they have their place, particularly for low-level matters. But often having them formalise it in writing allows you to respond in writing and make it in a very structured, logical way, and also allows you time to cool down. So if it's a clinical issue, the doctor should respond, and if it's a practice issue, then obviously a practice manager should respond to the complaint. Now let's just do a little bit with formal responses. So these will normally be in writing, and if it's serious, ask them to put it again. If it's verbal and serious, ask them to put it in writing. Clarify issues if necessary, and deal with the complaint promptly. That's your response promptly. What's promptly? I would say somewhere between 14 to 28 days. I don't think doctors have to break their necks and get back to somebody within 1 day or 2 days. That's unreasonable in a busy practice. But anywhere between 14 to 28 days is reasonable. And that could even be extended if it's reasonable to extend it. If there's things like you're overseas and you're the best person to respond to the complaint, then that's fine. But again, some explanation should be given to the patient about when they're likely to expect a complaint and why it can't be responded to in a timely fashion. Again, show empathy with the patient. It doesn't mean you're accepting what they say is correct. It's just you're accepting that their feelings have been hurt, or they have concerns, or they've had some anxiety from the interaction. And again, seek assistance with difficult complaints, even informal complaints, not ones made to the regulator. I would still seek assistance with those from your MDO. We do a lot of complaints which don't go to the regulator. Doctors come and seek our assistance, and it's always a good thing to do for those more complex ones. Now, this slide talks about what MDOs consider. I'd like to talk actually about what I consider, given that I've been practicing this area, and it's nothing inconsistent with that, with what's on this slide. But I normally, when I get a complaint, what do I consider? I look at the complaint and I say, how does the complaint read? Is this person sort of sounding reasonable? Are they making reasonable points? Sometimes you can tell from the complaint that there's some underlying issue. They might have a mental health illness, or there might be some issue the way it's written that sends alarm bells. The patient themselves might have problems, and you can tell straight away from the complaint. And it'll often be long. There'll be capitals. So I look at the complaint, just say, is it reasonable? Are they making reasonable points? And then I would assist the doctor or the practice to write something which is, measured and, recognises the patient's stress and concerns, and is, I won't call it diplomatic, but, measured and addresses all the issues in an appropriate manner. In terms of civil matters, you will get a feeling about, is this something that could become a civil claim? But I don't think that's a big determinant. I think what you've got to do when you get a complaint is answer it to the best of your ability and not worry about a bushfire being a civil claim 3 months, 6 months, or a year down the track. But just know when you do prepare a response, and I'll get to this it'll be in this next slide, just know that somebody else could be reading it. That response could go to the Medical Board of Australia, or APRA. The good thing about that is if you've done a really good response to an informal complaint, it really does lay the groundwork later on, if the patient's not satisfied with it, for making it look really reasonable before a regulator, and increasing your chances that the complaint will not go further in the Medical Board or APRA's complaints process. So I'm just changing slides. So taking up the point I just made, who will read it? So you got to think a third party could read it, like somebody at APRA. The person could take that letter to a solicitor and have them read it. They could give that letter to an expert. So just know it could be read by third party. So you approach drafting a response knowing that might happen. And again, acknowledge the patient's point of view. I'm not saying in saying that when I also say that, you should acknowledge their feelings, that you should always do that. Sometimes the response will be overly aggressive, in which case, instead of saying, you might just want to recognize that, you haven't been able to meet their expectation, their standard of care, and express a regret along those lines. And returning to how you draft it, make it factual, address the issues, clarify misunderstandings, which is quite common. An apology and an expression of regret, is appropriate. You don't have to, and I wouldn't be expressing regret along the lines that I made a mistake, I'm at fault. But you can say, I'm sorry, you feel this, I'm sorry this has happened. That's not saying you've done anything wrong. It's just expressing an apology or regret for the circumstances that the patient finds themselves in and for their feelings. If appropriate, suggest changes to your practice. There could have been some issue with follow-up or something not being scanned or scanned into the system or something, which it's a systems problem and it's quite glaring. It's okay to talk in terms of what you'll do to fix it. If you don't do it now with the patient in an informal complaint, you'll be doing it in the formal setting where they can make a complaint to APRA. So it's okay if it's really appropriate that you do it, because that's what a regulator is going to be expecting that you would do as a good healthcare professional. And that flows on a suggestion for any action that may resolve the patient's complaint. That could be the systems change, or maybe even seeing another doctor at the practice, or about the timing, about when you'll see them, or I'm not sure, but there might be a way. It might be appropriate to have a resolution to the patient's complaint in some particular way, rather than just addressing the medical issues and the communication issues. There might be some outcome that's appropriate. So, complaints protocol. I think some documented way that you can manage complaints is highly appropriate. It allows everybody in the practice principal, the doctors, support staff, and everybody to know what's going to happen when a complaint comes in, how it will be triaged and how it will be dealt with. One important matter when patients do make complaints is to, let them know that the complaint's being taken seriously. That helps when you acknowledge its receipt and give some indication about when you can respond. I'm just having a read, sorry. And I think the point there made about it being handled by someone with sufficient authority, I think that's a given. I think you would never leave support staff. I think to manage a complaint should always be managed by somebody with an authority, in terms of the patient's treatment and management at the practice. That can either be a practice principal if it's appropriate, the doctor themselves who saw the patient, or the practice manager if it's a practice issue. Sometimes I have seen practices respond on behalf of doctors after consulting the doctors, but when you do that, you tend to find that the doctor's response makes its way into the practice's response. So it's still the doctor's response, but they're just saying we've consulted the doctor and our response to your complaint is X, Y, and Z. So actually, I'm going very fast. Is any questions coming through if you want me to answer something?
No questions at the moment.
No, that's okay.
If anybody has any questions, please feel free to put it through the chat box.
Yeah. If I can clarify that point about frontline staff need to be trained to respond appropriately, I mean by that in terms of triaging and accepting complaints, and also about when it will be responded to, or what will happen to the complaint, where it will go. So I don't mean in that slide that frontline staff will be the people who will be responding, unless it's appropriate, like the frontline staff could be a practice manager who's always front of house and doing things, but there should be a way of dealing with complaints that everybody is aware of in the practice. So improvement process, and then this is a biggie for APRA and the Medical Board of Australia. It's often said that I've heard it said when I've gone to presentations with them, and that they do like to hear that a complaint is a learning opportunity. Sometimes there'll be no learnings from it. Doesn't mean that you don't reflect and say, well, was this communication okay? Could it have been better? Why did the patient make a complaint? You might find if you do that process, everything's okay. It is a matter of misunderstanding on the patient's part. But regulators like to see it, but it's also good medical practice that that takes place. You do pursue a learning opportunity for every complaint and adverse incidents too. If there's an adverse incident, that an opportunity is taken to see that, what can we do better? Can we do something better next time to prevent this happening? So I've mentioned, can we do something differently? Have you had similar feedback before that goes on? If there's a theme, if you get more than one similar complaint, again, that should prompt some form of review. Is more training of staff required? It could be that the complaint, not about the actual medical care, but more admin about how an appointment was made, how somebody was followed up by the practice, not necessarily always medical. And hopefully this process will lead into preventing a recurrence of a complaint in the future or complaints in the future. Now, managing a complaint from a complaints entity. Now, I should say the complaint from a complaints entity, obviously, it's not normal that a complaints entity will self-generate a complaint, though they can. Almost invariably, the complaint will be from the patient, but it will have gone to APRA, who will then ask you to respond to the complaint. So, and those ones, they're the ones I've said, I think it's important for the doctor to seek input from the MDO. I would not contact the patient and try and deal with the complaint, directly with them. Once it's with the regulator, with APRA, I would deal with APRA. The last thing you want to do is to be seen to try and move the complaint away from the regulatory body. It could be seen as potentially, I'm not saying anybody would think about doing it, but it could be seen as trying to subvert the process. And it might not help anyway. Once it's the regulator has it, well, they would usually see it through in any event. And one thing I wouldn't do, I wouldn't call APRA, the regulator. If you get a complaint and start talking about the complaint, and because my experience is when you do that, you're normally doing it when you're really upset. And I have had instances where the member's been so upset that the Healthcare Complaints Commission in New South Wales, or it could be the Medical Council in New South Wales, in your area, it'll be APRA, have called us concerned about the doctor because they've been so upset and so overwrought by the complaint. And it's not a good look. It's also then the doctor starts trying to deal with it then and there, and it's just not a good look. And often the doctor not putting their best foot forward in terms of responding to the complaint. So I would say don't call the complaints body and respond verbally over the phone, thinking that it will just go away by a verbal discussion, because it won't. And you could possibly be upset, and you won't come across very well, and you won't deal with the complaint very well over the phone. So my advice is don't do it. Main thing is you get onto your MDO and seek the input of your MDO who will help you with the complaint. And we do. I can't speak of other MDOs, but I know just in my jurisdiction, we deal with literally, I can't give you an exact number, but literally hundreds upon hundreds of complaints every year. I'm talking about in excess of 300, sometimes up to 600 a year. And that's just my team. We're going to go on now to online feedback. Basala, does anybody want to ask me anything at this juncture?
Yes. So there is a question that's come up. So the
Thank you.
question
Yeah.
is, would
Yeah.
you approach a direct complaint to practice differently if the wording indicates the patient has already had legal advice?
Can you repeat that, Basala?
Yeah. Would you approach a direct complaint to practice differently if the wording indicates the patient has already had legal advice?
Possibly not. If it's possibly not. It would depend upon what the letter. If the letter was basically, what I would do, what I'd strongly recommend, the approach I would take if it's like that. If you get an amber flag saying, and I've sought legal advice about this, I would send it to your MDO. Okay, I wouldn't. That's one class of informal complaints I wouldn't do on your own. I would send it through your MDO. I have had experience where patients have said that. I even had experience where informal complaints have been made by solicitors on behalf of patients. It doesn't mean you don't deal with them because it won't get any better. Like you might not complain, but then they'll just if you don't deal with them, they're still going to complain to APRA, or they'll still commence civil litigation. And so there's still an opportunity there to try and respond to the complaint again in a measured way. But in those situations, because there's an overlaying possibility that the complaint, your response to the complaint may be used against you in civil proceedings, I would go to your MDO. I wouldn't do those complaints on your own. Okay, I think that's one class of informal complaints I wouldn't do on my own, and I can't. And I'm not saying don't respond, but I'm saying respond with your MDO's assistance. Okay, and you'll probably find when those trigger words are used, like I've gone to my lawyer and how do you explain this? Most times that type of complaint will trigger your notification requirements under your professional indemnity policy of insurance anyway. So it's probably a complaint you have to report to your insurer in any event. But before actually dealing with, could I just ask, is that okay if I deal with that answer? Yeah.
Yeah.
Okay. Yeah, that's one class of. I've said a complaint or complaints entity. I would always strongly recommend doctors go to the MDO. The informal complaint, and I've said with informal complaints, I encourage doctors to go, especially written ones, and when they're fairly significant, to go to the MDO. But definitely when they involve mention of lawyers, I'd always go to your MDO, and that would trigger your requirement to notify your MDO in any event. So I'd have to go to your MDO. But before I go on, there's just one thing I just want to let the people here know. When I was talking about not being too defensive in terms of apologising, under your Civil Liability Act, Section 75 in South Australia, it reads, just gives you a bit of comfort. It reads in terms of a civil claim for damages in the District Court or Supreme Court, it reads, in proceedings in which damages are claimed for a tort, that's for a wrongdoing, no admission of liability or fault is to be inferred from the fact that the defendant or person for whose tort the defendant is liable expressed regret for the incident out of which the cause of action arose. Okay, so that should give you some comfort that if you say, look, I regret this happened, I apologise. An apology can be an expression of regret. If you say sorry, for what's happened, that doesn't mean what's happened is, due to somebody's fault. That should be protected and shouldn't be admitted in a court of law in South Australia. And one thing before I go on to online feedback, just to give you a bit more comfort, whatever you put in a complaint in terms of facts is admissible, but issues to do with fault are normally for a court to decide. A layperson's not going to know whether they've been negligent, if you know what I mean. So it's normally something for a court to decide, not for a layperson, to make a determination over in their own right. Somebody could say they've done something wrong and they haven't. So even that error, if you did do it, it's not catastrophic necessarily. So let's go to online feedback. This is a brave new world. I grew up with just a fax paper coming in, faxes coming in. So it's all changed for me with online feedback. But it's all there. You can see all these, search engines, these days, Facebook and Google. and it's growing. It's growing year on year. It's a way that, in a modern way, that doctors and practice receive feedback, but sometimes people, don't let you know who they are when they're making posting a review. Mention is made in this slide. Gaming is where competitors post adverse comments about you for personal gain. If that's happening, it would be really unfortunate. I'm not saying it's not happening, but if that happened and you got caught doing it, you could be in difficulty with the regulator. So I wouldn't be doing that. I think it's I wouldn't be doing it. It's just too dangerous. So it does mention that we don't know how many people are using doctor-patient rating websites, but we do have a feeling that it's growing. I think there's studies overseas showing, like in the UK, one study showed there's about 3% are using posting things online, and in the USA it's 11%. But it's growing exponentially from what I can tell, because we're having a lot more members and AMP members coming up talking about things being posted online about them, which is not, which they feel is unfair and untrue. So from that perspective, you can feel it's a growing area. One good thing is that there's very little evidence of a link between the quality of healthcare and a doctor, as a result, and practice ratings. You can be a great doctor and still get poor practice ratings if they don't always align. And actually, there is a study that showed that, an overseas study. So I don't think a bad review is always catastrophic. So what do you do about them? Now, this is probably the hardest thing to do, is do nothing and wait. Sometimes the complaint will be buried after a while if you're having a lot of reviews put on, and so what's at the top will go further down. But you also might find that it's balanced out by a whole lot of good complaints. So there is always the option of doing nothing, and I think one bad review, often from what I've read when I've helped members with them, they'll often you'll know when you read it that you don't believe that they can be taken seriously, because it's just sometimes so unreasonable that any third party reading it just won't buy into it, especially when there's positive reviews either side of that one complaint. There's one thing that you shouldn't do, is trying to counteract bad reviews by encouraging people to put positive reviews about you. And I say that because testimonials on your own website aren't allowed under the guidelines, and so I think that would be getting close to that. If you had other people put stuff up on other websites, it might be thought to be inappropriate by the regulator. So I wouldn't be going there. And some people actually also, I hear there's specialists who can actually help drop down, if it's online, drop down the negative rating, so it doesn't appear as high up as it normally would. But in any event, doing nothing can be a viable option, and when in particular where you have a lot of other good complaints and it's apparent that this complaint is just wholly unreasonable, you might not want to spend time trying to get it removed. Now, responding directly to the patient is an option, either online, but I'll talk about that because you have to be really careful, or directly. Now, doing it directly, you obviously have to be able to recognise who the patient is who made the online comment, and then you reach out to them and try to resolve the issue. And hopefully, if you do that, they might consider taking the review down because their grievance has been addressed. Alternatively, maybe put another post up saying that it's been addressed. Now, you can also respond online, but I would caution against responding online in terms of any trying to deal with a medical complaint, like, about their care. Because the danger with that is you'll say too much and you'll breach confidentiality. I mean, you could argue that the patient's breaching confidentiality by already telling the world that, I went in for, this pain in my leg and the doctor misdiagnosed it. But there might be more than, you might need to say more in terms of responding to that medically, and you might find that the length of response leaves you open to a complaint of breach of privacy. And who'd want to try and deal with a complaint, a difficult medical complaint online anyway? It becomes very difficult. So I wouldn't be advocating or advising trying to deal with those types of complaints online. I would reach out to try and encourage a plaintiff to if you can address their concerns directly with them, but I wouldn't be doing it online. Some things that can be addressed online, they would be things to do like, the parking situation, or, something to do with the environment in the office or waiting times. They could be addressed online because they don't involve disclosing personal medical information. So that's a possibility. But putting medical information, responding medically online, I haven't really seen that happen yet. So I just think it's too dangerous to do it, that you might say too much, and so I wouldn't advise doing that. This just basically is a rehash of what I've just said, a recap. I shouldn't say a rehash, doesn't sound good. It's a recap of what I've just been saying in terms of responding directly to patients' comments online. To be very careful not to breach privacy. Make sure you do not want to respond when angry. That's a fantastic point. Ensure your response is caring and shows a willingness to take on feedback. So you could go online if you don't know who the person is and just say, encourage them to reach out to the practice, and so you can discuss it. That's viable because you're not discussing the medical treatment. If it's really inflammatory, I would encourage, and you're really concerned about it, I would really encourage you to reach out to your MDO and have a chat about how best to respond to the complaint, what strategy you will use. But whenever you post something online, you do try and keep it simple. You don't want a paragraph or 2 paragraphs. You tend to try and keep it to the point, 2 or 3 lines in saying something like, note your complaint. Sorry, we didn't meet you weren't satisfied with your care or with your presentation that day. We'd encourage you to contact the practice so we can discuss it further. Something like that. Now, asking the website to remove the comments. That's possible, and that there has been some success in that, but it doesn't always work. Websites will remove comments when they're inappropriate according to their rules, and also if they're breaching any particular laws in the jurisdiction. They could be highly inflammatory in terms of endangering some form of hate, race. They could be racist. They could be sexist. All those will probably infringe some form of rule by one of these, websites, and there's a chance you'll have it removed. If it's perceived by the website to be a fair comment, they're not a good comment, they're not a favourable comment to the doctor or the practice, they're likely not to remove it. But if it's something that infringes the rules, and again, the rules will be about what I've just discussed, something to do with if it's, they go to, issues of race, religion, they're inflammatory, they cross the pale in terms of saying how bad the doctor is, calling him a butcher or whatever. Those things can often be removed. I've seen them removed. But if it's just a bad comment with none of those, if it's just a bad review with none of those trimmings or comments, you're probably going to find it very hard to have them taken off the website. But that's a possibility. And again, with that, you approach your MDO you try and get the rules, and there could be also specialists who could help you in terms of dealing with the website owners to take it down. But definitely go to your MDO also and seek their input into an inflammatory comment in particular. Now, the last is commencing defamation proceedings. It's there, but it's very expensive. You do have to prove that you're defamed and that the defamatory comments were untrue. Oh, sorry, you defamed. That means that the defamatory comments were untrue. They had no foundation in fact, and they damage your reputation, and that has caused you some form of damage. And then that can be valued by the court, and you get an award of damages. Now, doctors do go down this route. It is hard. There have been at least 5 cases that I'm just trying to count it in my head, that I've seen in the last 2 or 3 years by doctors who successfully sued patients. A lot of them have been very extreme defamatory, not even one comment, but a campaign of defamation for one doctor who was a surgeon, and the people defaming him were doing things like putting flyers on cars and posting things online repeatedly. So that was extreme. It was almost a campaign, and he was awarded, I think, close to $500,000. But it can be very trying, and everything comes out, in defamation action. So when you challenge somebody, they will try and throw mud if they can. They'll try and show that their comments are true in somehow. So that's the downside. And in circumstances where I've seen doctors successfully sue a patient for defamation, it's been almost unassailable that the comments have been clearly defamatory, and they've been able to prove it. So before you'd sue anyway, you'd go and see a solicitor, and possibly they'd brief a barrister who practice in defamation laws, and you would get really good advice about whether it's viable and appropriate for you to commence a defamation action, because they're very expensive. So you'd have to bear that in mind. So it's not easy. It's not what people jump to. It tends to be a last resort. So this is just a bit of a recap in terms of preventing patient complaints, and good communication, both doctor on patient, practice on patient, sound policies and procedures, but not only complaints procedures, but follow-up and escalation of care out of hours, respond to complaints with the quality and improvement focus to minimise future complaints, and make it easy for the patient to complain to you directly, actively seek their feedback, and so reduce the need for other feedback routes, such as them going online or going to APRA, which is often what they do. And again, it's the reflective piece. Can you do anything different? Actually, I think we've seen this slide before. Sorry, it's a repetition, I think. No, sorry, slightly different. So is there just, again, reflective piece going, can you do anything differently? Is this a theme? Is this something you should raise with your practice? And should your policy or processes, I'm talking about your complaints policy here, I'm talking about general policies and processes in terms of managing your medical practice, how you deal with results, how you deal with follow-up, those type of things. Should they be reviewed and improved? So ending the doctor-patient relationship. There's no, in your jurisdiction in Australia generally, there's no compulsion that you have to see somebody. If the therapeutic relationship isn't working and it's in the best interest of the patient to terminate the relationship, you can. And again, there's no impetus to see somebody. The only time that there's an issue in terms of not seeing somebody or terminating somebody is when it involves something, because it's something inappropriate, like some form of because of some form of discriminatory behaviour, which is relatively rare in my experience. But other than that, which most people, those things aren't even on the playing field. You have no obligation to see a patient except in an emergency, and you can terminate a doctor-patient relationship if you feel that the patient's not listening to you, there's a lack of trust. You don't have to continue. You can actually cease a doctor-patient relationship. So how should you do it? Is the big question. Most times, I think having a discussion with the patient is the best way to go, but sometimes, and followed up with something in writing, and we have a template letter that members can adapt for that. We actually also have a fact sheet on terminating doctor-patient relationship and template letters built into that, and a follow-up letter. But occasionally it's going to happen that you can't do that. And that will be circumstances where the patient has been relatively, they've been bad, basically. They've been extremely rude to your staff or to yourself. They've been very aggressive. And that issue of a face-to-face consultation or meeting where you terminate the doctor-patient relationship might not be possible anymore. A face-to-face also can be by Teams too, or telephone. That's another way of doing it. If you can't do in-person face-to-face telehealth or telephone conversation, but sometimes, as I've said, it won't be possible because the patient has burnt too many bridges. In which case, sending them a letter following some bad behaviour, saying don't come back, you've burnt your bridges, is quite appropriate. The only time you'd be required to continue seeing the patient is if they're in an acute phase of their care, or it's an emergency and you can't hand them over. That's about the only exception that you're caught by. Other than that, it's quite appropriate, and you just got to be able to manage the patient going to a new practice, offering to send their records to a new practice on receiving an appropriate authority from that new practice for transfer of the records to that new practice. But just to go back, I just got a few other reasons why you might terminate a doctor-patient relationship. I've talked about behaviour, when you've had bad behaviour. I talk about a lack of trust, and that I'll just want to expand upon that slightly. That could be when the patient's just not listening to you. They're not taking your advice. The only advice I'll take is when it aligns with their own opinion about what treatment they should be having. That's a lack of trust. Also, if a patient makes a complaint against you, either to the practice, to yourself, or to a regulator, that's an appropriate time to review whether or not you should be continuing with them, and whether it's because the last thing you want, particularly if it's gone to a regulator, most times you would never continue the relationship because you don't want to be stuck with any assertion by the patient that complaint has somehow tainted your ability to look after them objectively as a patient. So normally, if it is a formal complaint, that'll probably be the death knell to continue seeing them. And obviously, I've said bad behaviour, and it could be a single significant event that will cause that termination of the doctor-patient relationship. It doesn't have to always be sustained behaviour. It could be one bad episode that will see the doctor and the practice terminating the doctor-patient relationship or the practice-patient relationship. So that's terminating the doctor-patient relationship.
Yeah. Paul, there's about 2 questions in the question box. So the first question is how to avoid breaching confidentiality when actually dealing with a patient complaint. A patient once made a complaint and I was unsure whether and in how much detail I should discuss with and seek advice or second opinions from colleagues, line manager, practice management, external specialists, etc. Essentially, my question is, who can you discuss the specifics of a complaint with? Should you only discuss with MDOs and nobody else?
No, I think MDOs are great because they'll have claims managers who basically all they do is this. They'll have medical advisors and they'll have solicitors like me. So it's okay. But you can have confidential discussions with patients about complaints. You don't always have to put names there. I would be very wary to to talk about the complaint very widely, because what could happen then, somebody who you've spoken to, maybe the fifth or sixth person, might not respect your request that it be treated in confidence. So I think you want to talk to the complaint and how you're feeling about the complaint and where you sit with the complaint with a peer, a trusted peer, and you don't always have to talk about who the person is, because it often won't be relevant. But often, if it's in the same practice as yourself, it's a good chance that the doctor will know who the patient is, in which case there won't be any issue of confidentiality, because they'll probably know the background to the patient. If it's somebody external, I wouldn't be using names, except if it's your MDO, because then you're doing it under, there'll be a lawyer or claims manager, and it'll be in a complaint setting. And so they need to know, they'll need to access the records, they'll need to, the full thing. There's no limitation when you're dealing with your MDO and the people they allocate. But in the non-medico MDO setting, it can be a close colleague, particularly in the practice, if they know of the patient and they know, that'd be quite appropriate in my view. If it's outside the practice, and again, that could apply in the practice setting, that could apply to the practice manager. If they in some way know the patient and they're connected, and there's some issue that falls over to them in terms of the complaint. One thing you want to avoid is, if they're involved in the complaint, being seen to get together to try and make up some form of, aligning your evidence. You always want to have your own type of responses to something. It's okay then to put them together into a practice response, but you don't want to be mixing your evidence up too much. So I hope I've answered that. I think don't make your support group too wide. Keep your support group tight and trusted people you can trust. You don't always have to talk in terms of names, and often the people you'll talk about in terms of, if you do talk in terms of names, they'll often know who you're talking about anyway, because they'll be in the practice, or in the practice and know about the patient and even know about the complaint, potentially, because maybe they've also have been made mention of in the complaint. So like, I've seen him and he was okay, but then I saw this person, so they'll probably know this particular patient. So I wouldn't go too far. I would keep it to a nice cohort of people you can trust, and it's not always necessary to use names too. So you can speak to people without giving names up, and still do it on a confidential basis. Can I have a confidential? I need to speak to you about a complaint I received at work, and having that discussion, telling them everything, which is to help you deal with the complaint that's been made against you without necessarily breaking privacy.
The second question was, complaints from patients suffering paranoia, delusion, cognitive impairment, etc., where the complaint is clearly a manifestation of their disease, can it be handled differently in any way?
No, I wouldn't respond to it differently. You can understand a little bit more compassionately that the person's got problems, and you would just try again, deal with it rationally, because again, you got to figure that whatever you write to that person, it might go to a third party. So I've done this myself on behalf of doctors, where I'm dealing with somebody who does have mental health issues, and the responses are just, they're full of delusions, paranoia, but I still put back a measured professional response to them. I don't, I try to be really even and cool with them, because I always draft things knowing that, I might have to attach it to an affidavit, or, send it off to, do something with it to support my position. And I also think it's respectful anyway, that, you do it that way. So no, I wouldn't treat a response. And I know it's a great question, because I actually have seen those responses from people who have mental health issues and they're full of delusions and paranoia and they're just wrong. I would still treat them the same way.
Third question is, how about...
I was going to say, with those ones, you don't necessarily have to go on about, I'm sorry, being effusive, because about their situation, you can express, look, I'm sorry you've complained, but you've done nothing. Often in those cases, you've done nothing wrong. You just got to be able to set out in a nice measured way why they're wrong. Hopefully they can accept it. If they can't, then you've done your best.
The third question was, how about the reception? They have access to patient notes. Are we responsible for the breach of confidentiality if they read the sensitive notes?
Yeah, that's a really good question too. And actually, thanks for thinking, so bring it to mind. When patients go to a medical practice, they legally, actually under privacy law, shouldn't be able to see other people's medical records, okay, and read their names and their addresses on folders and stuff like that. Now, if that's happening, that is a breach of that person's privacy, and I would be speaking up to the practice manager or somebody to let them know that. But will the doctor be liable? No. Generally, if you don't own the practice, you can't be liable for it. Okay, if you're a contractor in a practice and somebody else is doing it, then you can't be liable for it. But I would be, as a measure of trying to control risk and do the right thing, I would be saying that leaving patients folders and seeing their names, is a breach of privacy. So now, an individual contractor, person who doesn't own the practice, is an individual contractor, just works there, and the records are owned by the medical practice, and the whole place is managed by the medical practice, you're not responsible. If the practice is responsible for that.
I think that was all for questions.
No, good questions. Thank you. Well, they were. Well, I think we'll just continue because we're almost done. So just key messages. Communication is key throughout the complaints process. Resist the urge to respond in anger. Have systems and processes in place to manage any complaints, and look after your own well-being and stress levels. I think that's really important. Again, another look after yourself email. I can't stress enough that you should really look after yourselves. And going back to the question a little while ago, who can I speak to? It's quite appropriate to speak to people to try and resolve and deal with your stress when you do have a complaint. But just know we are all human, and everything will be dealt with. Seek assistance, and your MDA will support you. We at Avant, we try to support our members 100% through things like this, and through your MDO and your own core group. Just utilize those supports to see yourself through this process, okay? Just to let you know, when I'm involved in a complaint for a member, I will always let them know that I'm always there to speak to them about the complaint. Don't muse and not to muse about what may happen. Best to call me, call the professional, and just talk it through. Don't get up at night and think about something and then just ruminate all day. Give the person a call who's looking after your matter and get an answer. And don't, because often the answer will resolve your anxiety. You're worried about things you shouldn't be worried about. People always think, oh, will this affect my registration? Will I be deregistered? In my jurisdiction in New South Wales, of the complaints that go to the Healthcare Complaints Commission, you're equivalent of the of APRA. 52% of complaints, last time I've heard the statistic, just finish up with no further action straight away. Okay, so they don't go anywhere, so it's often very like the case though you stress, the complaint's not going to go nowhere. That's why you need some advice about what's likely to happen, so you can put your mind at ease that how the complaint, if it's a formal complaint, is going to play out. So that's the end of my presentation, people. But I'm happy to take any further questions.
That was very, very good. Thank you, Paul. At the moment, there is no questions. I think you've answered really, really good ones. We've had all of them are really good. Yeah.
You have my email address, Lucella. I'd be very happy if you want to give it to people, if they want to email me, they can send me an email. I'd be very happy to get back to people, and respond to them if they have any questions arising from the presentations. No problems about that.
Perfect. Thank you so much, Paul. And just thanking everyone for attending as well. The resources of this presentation will be uploaded on our website as usual. And any questions, please feel free to send forward to me.
Yeah.
And then I'll pass this on to Paul. Yes, apart from that, please don't forget to fill out our evaluation form at the end of this session, and have a lovely evening. And thank you once again, Paul. It's been a very insightful presentation.
No, thank you for having me.
Yeah, we look forward to seeing you on our second session next month. Thank you so much.
Thank you, guys. Have a good evening, everybody. Bye-bye.
Bye.